PTPH2 is easier to navigate. For example, there's a button to take you straight to the PTPH2 form. It's up here. Click on Case, and amongst the options we now have Open PTPH Form. Click on that, and the form will open in a separate tab. The form itself looks broadly similar to that which you're used to, but notice that the grey side menu here has been shortened. That means there'll be much less scrolling up and down, but of course not every title features here. For example, to go to the Stage 1 orders, just click on Stage 1 and there they are. PTPH2 has a single witness table. In the blue section here, the prosecution can insert the witnesses that the prosecution anticipates may be called. The individual witness requirements can be indicated by the parties using this section, and the relevant issues inserted. The judge can consider the witness requirements and confirm them or not, as the case may be here. And if it's possible to do so at PTPH, special measures may be granted, or a witness summons may be issued. The section can have an additional witness added simply by adding that, which is pressing the green button, and that section can be removed if you've got too many by removing using this red minus sign. If you do that, you get a warning that the row will be removed, just asking you to confirm whether you want to do that. Let's click OK. Also on this section you will see that there are some green boxes. These boxes allow sections to be expanded like that. This shows you the details for how to insert witness requirements, but you won't need to read those every time, and therefore it can be collapsed so as to not interfere with the rest of the form. Another section here, which has got a green tab, is here, which is intermediary known at PTPH. If an intermediary is known at PTPH, then the details of that intermediary should be captured and the availability considered before setting the trial date. Simply click on the green button. That expands this section, which allows the information about the intermediary to be recorded. If you don't need it, then simply collapse the section by pressing the red button. The advantage of these green and red buttons is that if a section is not required, then that section will not appear on the final PDF version of the form. The form is designed to capture more information for disclosure purposes. Thus, in the Prosecution Information section, as we scroll down, there is a section which inquires, has a disclosure management document been provided? And does the prosecution believe that any third party holds potentially disclosable material? Notice that in these instances the prosecution have clicked a box to say no, namely a disclosure management document has not been provided. That has resulted in this orange triangle coming up, which is a clue that perhaps an order needs to be made about that topic. As far as the defence are concerned, they too need to participate in disclosure, and therefore in this section we have a question: is any served disclosure management document adequate, and if not, why not? Do the defence agree the reasonable lines of inquiry, and if not, what other lines of inquiry are suggested by the defence? And do the defence agree the level of extraction of data, and if not, what levels is said to be necessary by reference to the issues in the case? Now, of course, it may not be possible to provide full information at the PTPH, but where information can properly be provided, then it should be done at this early stage so that the necessary inquiries can be made. Down in the Stage 1 orders, one of the things that a judge may consider making is an order here for an updated or initial disclosure management document to be provided at that stage. And in Stage 2, the defence are expected to provide a response to the prosecution disclosure management document if served, identifying by reference to the issues in the case any disputes as to reasonable lines of inquiry or levels of data extraction. It remains important for the Stage 3 and Stage 4 dates to be set because, of course, the first Stage 3 order is for the disclosure of items required to be disclosed under the CPIA resulting from or requested by the defence statement, and Stage 4 is the date by which there should be a complaint about prosecution non-disclosure to comply with Section 8 of the CPIA and Criminal Procedure Rule 15.5, and perhaps an application for a witness summons for third-party disclosure if the prosecutor indicates at PTPH that they will not be pursuing any third-party disclosure issues, or any defendant is dissatisfied with the outcome of prosecution inquiries. PTPH2 automatically inserts certain dates. The prosecution will provide the date of sending to be inserted here against the details of the defendant, and of course the custody time limits. The form contains a place for it to be indicated whether a person is in custody or on bail. Using that information, the form is capable of automatically calculating the Stage 1 date, and that will automatically be inserted like this. It will also insert the Stage 2 date like that. As with all dates, the dates can be altered at the will of the parties or the judge. Thus, clicking on that date box will now open a section which is of 2 months. That makes it easier, for example, to expand that date by 28 days, 1, 2, 3, 4, to the 4th of December. When a date is changed like that, there is an opportunity to insert a note about the change. But when the form is saved, that box disappears. Another feature of the auto-insertion of dates is in the trial section. Where a date is inserted for trial, here, I'm going to bring it 2 weeks earlier, the date for the Certificate of Readiness is automatically changed too. The Certificate of Readiness date is automatically inserted at 28 days before the trial unless it's manually altered. For example, I'm going to change it to 2 weeks before the trial, like that. There have been problems with failing to record vulnerabilities on the part of defendants, particularly young defendants, or defendants who are vulnerable in other ways. The form seeks to capture that information in a better way. Therefore, the defence are required to indicate whether the defendant was under 18 at sending. If the answer to that is yes, then an orange triangle appears to draw attention to it. 2 other questions are designed to bring out particular vulnerabilities. So there is a question, is the defendant vulnerable for a reason other than or additional to youth? And the question, is the defendant said to be a victim of modern slavery, in which case the court will wish to consider a variety of measures. What if there is a vulnerability? Well, there is an obligation on the court under the Rules and the Practice Direction to consider what measures should be made to address that vulnerability, and much of that can be dealt with at the PTPH. There is therefore now a drop-in section which is found just below the witness table. Just here we have a single line which says young, vulnerable and intimidated defendants, measures to assist that can be granted at PTPH. If you click on the green button, then that opens up a menu of possible orders. It starts with the point that the court is required to give reasons for departing from the relevant provisions of the Criminal Practice Direction, and it identifies these sections of the Criminal Practice Direction which name various measures which are appropriate for vulnerable defendants. Grant Morris is the case which requires that the court should record those measures, and this drop-in section is there to provide an easy means of so doing. Thus, the directions apply to the named defendants. During the court proceedings, the defendant is to be referred to as, usually, a first name. There are then sections to consider any orders about publicity, for example, a Section 45 Youth Justice Criminal Evidence Act order restricting publicity. Other issues that need to be considered are the issue of severance, the question of a ground rules hearing, of an intermediary, suitability of a video link for non-trial hearings, and then other measures such as, for example, where the defendant is going to sit and whether a supporting adult may sit with the defendant at trial. There is of course an opportunity to make any other specific orders. If the box there, Other Orders, is clicked, then this section lights up and any orders can be inserted. Any items that are not clicked, for example, we might decide that wigs and robes are not to be worn, dock security staff should wear civilian clothes, but for example all the other orders are not required, then because they've not been clicked they will not appear on the PDF version of the form. As for special measures to assist the defendant to give evidence, if the defendant seeks additional special measures such as the use of live link, then it's appropriate to have a formal application at stage 2 and provision is made for that. It's also important to record whether the judge has or has not given an oral judgment on the measures required. That again is one of those things that the judge is supposed to do under the criminal practice direction. The form is shorter in overall length because sections which are only required in certain cases are dealt with by way of knock-in sections. Thus, for example, if there is a need for a pre-arraignment further case management hearing on, for example, dismissal, then orders can be given by clicking on the green box, and the relevant boxes are then available to make the necessary orders. If that's not required, then nothing will appear on the final PDF. There are of course special provision for Section 28 when it becomes widely available. Those directions have been developed by the courts which are piloting that process. The other feature which will make the form shorter is that the stage orders need to be considered separately. If the judge decides that something is not applicable, for example, that there is no multimedia evidence in the case, then simply clicking on the Not Applicable button, ditto there's no raw record of interview, we don't want any audio, we don't want any 999 call information, will grey out these sections. The result will be that those orders will not appear on the PDF version. The form has been updated to take account of changes in law and practice. To give just 2 examples, in the standard orders for witnesses and defendant, there are a series of orders which apply to every case unless countermanded by a specific order from the judge. Amongst those is an order in respect of young or vulnerable witnesses or defendants. It provides that young or vulnerable witnesses or defendants to whom an Advocate's Gateway Toolkit or the ICCA 20 Principles of Questioning apply are to be examined and cross-examined in accordance with those principles unless those are superseded by specific ground rules. Equally, towards the bottom of the form we have the final judicial warnings to be given by the judge at the end of the PTPH. These are recorded by ticking the boxes, and if the box is ticked then that warning will appear on the PDF version of the form, but not otherwise. They include a reworking of this final warning, which now reads, if the defendant fails to attend trial, the trial may proceed in his or her absence, in which case advocates may withdraw and the judge may inform the jury of the reason for that absence. Saving and publishing has been made easier. For the parties, it's important to save the information that they've inserted on the form. Thus, for example, when the defence have finished completing the defence information section, they will want to go and press the Save button at the top of the grey menu. That saves the information that they have inserted. If they subsequently want to make a change, for example, that they've recalculated the date when the defendant was born, realised that he was not under 18, then making a change is easy. That will provide a little change note here, and that will disappear when they resave the form. The parties are welcome to save as often as they like. In the past there has been a problem with the parties creating PDF versions of the form, sometimes multiple versions. The judge, when he or she has completed the work on the form at the PTPH, simply presses the Save and Publish to Bundle button. This is not a button which should be effective for the parties. Once that button is pressed, there is a brief. Notice that the form will be available shortly in the PTPH and the Judge's Orders section. There will be a brief windmill effect, after which it will be possible to carry on working in other ways. That should be much quicker than the old process. The PDF version of the form is, we hope, much clearer than its predecessor. Once the form has been saved and published, then the entirety of the form appears in the PTPH form section, section S. Here's an example. As you see, the layout is much clearer. There's the information about the defendants, details of the contacts for the prosecution and the defence, and the information put in by the prosecution and the defence, together with the other information provided. The Judge's Orders section of the form is separated out and sent to the Judge's Orders/Directions section X. There it is. In this instance it has the details of the case, it has the details of the judge at PTPH, and it has the witness requirements and information about each of the orders made. Just for example, the Stage 2 orders are relatively few because the judge in this instance greyed out as not applicable various orders, and therefore they do not appear on the PDF version. Scrolling right the way down to the bottom, there are the usual final judicial directions, warnings to the defendant, which have been updated to take account of the changes in the law.